evening. What time is your class? Because it might, I think we have, like, even if you could just
I could do that.
poke your head in. Anyway, yeah, so, no pressure, but sits over there.
I was actually complaining about that too, but then I came in with all of them.
Yeah.
All right.
This is the cool door.
We're going to get started. Thank you for joining us today at PIJIP's informational series about the Supreme Court IP oral arguments. As you know, we every time the Supreme Court takes an IP case, and this year is especially abundant year for IP cases, we hold a panel on the day of oral argument discussing what was argued in court that day. And so today we have the case of Peter versus Nantkwest Incorporated. It's our first patent case of the year, won't be our last. We have a distinguished panel today. I will briefly, because it's very distinguished, it's a very large panel, I will give a very quick one-line statement about who these people are, and then I'm going to turn it over to them, hopefully so they can give you a brief summary about their interest in the case, where it comes from, and how they think the case should have come out. We don't know yet, but how they think the case should be decided in 2 or 3 minutes. And then we'll get into questions about what happened today at oral argument. So to my immediate left, Charles Dwan. He's with R Street. He argued on the side of the PTO. He was in favor of the PTO. Then next to him is Greg Castanis. He is a partner at Jones Day on the Federal Circuit team. Next to him is Pamela Chestik. She is the principal of Chestik Legal, and she practices trademark law. She's going to give us the trademark insight into today's patent case. Next to him is Tom Irving. He's a partner at Finnegan, and he also has about 40 years of experience doing patent cases. Next to him is James Tupin, WCL's very own James Tupin. He is a former general counsel of the USPTO, so he will have opinions about PTO's position today. And last but not least is John Mills. John is representing the New York City Bar Association today. So please join me in welcoming our panel. Let me turn it over first to Charles to state his involvement and what is his preferred outcome in this case.
Thanks, Joas, and thanks to PIJIP for having this panel and for having me on it. I was a somewhat late addition because of some scheduling conflicts, so I was glad to be able to join. I think that, I've been fairly impressed by the amount of press coverage that there has been for this case. There is a CRS News news piece on the case. There's a piece from the Legal Information Institute on the case. Law 360, of course, covered it, which is kind of surprising for a case that deals with a random section about expenses for the USPTO. So I'm glad to see that so many people are interested in weird topics of patent law. I guess since nobody else is here to do it and I'm the first one to speak, I'll give a little bit of an overview of what happened in the case before I go into what I want to talk about. So this case deals with Section 145 of the Patent Act. Generally, if a patent applicant is unsatisfied with the patent office's treatment of their application, they have 2 judicial options. They can go directly to the Federal Circuit under Section 141, or they can go to district court under Section 145. They can bring an action in the district court. The district court supposedly offers a number of additional benefits to the litigant. For example, they can bring in expert witnesses, they can have depositions, a number of other things that courts have pointed to over time. But Section 145 has this unusual provision, which is that the applicant is required to pay all the expenses of the proceeding. It appears that kind of applies regardless of whether or not the applicant wins or loses. So, if the applicant even if the applicant prevails over the PTO, the provision would seem to read that they have to pay the USPTO's expenses. And the question in this case is, what does expenses mean? And in particular, does expenses include the cost that the USPTO outlays to hire lawyers within the USPTO? What I think most people would consider to be in-house attorney's fees. So the patent office argues that this is simply a matter of plain meaning. That the term "all of the expenses of the proceeding," the ordinary meaning of expenses ought to include fees. That's how most people would understand an expense. An expense would be an outlay of money that is necessary in order to accomplish a certain task. And so based on that, they argue that they should be entitled to win their attorney's fees at the end of the day under a Section 145 action, regardless of the outcome. The position that I take is it's in support of the government, but in a sort of odd way. The point that I make is that I started out by saying that you have two options. You have two judicial modes of of recourse if a patent applicant is unsatisfied. But a lot of people have kind of made this mistake of saying you have two options. And that's not correct, because a patent applicant who is dissatisfied with what the patent office does has three options. They can go to the federal circuit, they can go to district court, or they can go back to the patent office. In fact, they can go back to the patent office as many times as they want, just paying more and more fees for continuation applications, and eventually get lots and lots of forms of recourse that people have said are sort of central to Section 145 actions. And based on this, it strikes me as less unusual than some of the parties have made it out to be that the PTO would charge for all of the expenses of the proceedings, including the attorney costs, because of the fact that patent applicants actually have this much cheaper alternative of just staying with the administrative system. And I think based on that, I tend to view the government's argument as less unusual than I think a lot of the other parties have made it out to be.
Well, again, my name is Greg Castanius from Jones Day. My interest in the case is that I authored, along with my colleagues, the amicus brief in support of Nantkwest's position on behalf of the IPO, the Intellectual Property Owners Association, and also authored their amicus brief to the in-bank Federal Circuit in support of the Nantkwest and IPO position. Before I say anything else, the usual understanding of doing these sorts of panels applies, and that is that I represent clients. I represent clients in a lot of different situations and circumstances, and so what I'm going to say here is not going to be used against me or my clients in any proceedings. You may use it in favor of me or my clients for any proceedings, but not against. That's aside from getting a little laugh out of the audience to make sure you're still awake at this hour. I also want to make sure that we can have as free a discussion as we can here, and I think that I think all the other panelists would probably join me in saying that. The statute that Charles has given us a little bit of background on actually originated in the Patent Act in 1839. So it's been around for quite a while. And the United States Patent Office only came up with the view that this statute, which says that the party initiating one of these district court challenges to the patenting decision of the Patent Office shall pay, quote, all the expenses of the proceeding. Only in the last 7 or 8 years did the Patent Office even come up with the idea in both patent and trademark cases where there is a similar statute that expenses of the proceedings should be understood to include a pro rata portion of the government's attorney's fees. This is, in our view, a remarkable, indeed breathtaking interpretation of the law, which takes with it the background principle of the American rule, which everybody learns usually in their first year of law school, that in America, everybody pays their own attorney's fees, unless there's a really narrow exception, which is either there's a statute that clearly says you get your attorney's fees, or there's an agreement between the parties that provides for attorney's fees, or there's been the sort of extraordinary litigation abuse that merits the award of attorney's fees under the court's inherent powers or one of the specific statutes that allows for the award of attorney's fees. in those circumstances. IPO's position, consistent with Nantkwest's position, is relatively simple. This statute says all expenses of the proceeding. It does not say expenses, including attorney's fees. And while it is true that the term expenses, when it's used in its ordinary meaning, divorced from context, divorced from the litigation context of this statute, expenses could include anything that you expend money on. That's not what the American rule says. And what the American rule says, rather, is that there's a presumption that, absent saying something fairly clearly that indicates that attorney's fees will be shifted, that each party will bear its own attorney's fees. That's even more the case, says IPO and says Nantkwest, because here the award of attorney's fees, or pro rata counsel costs, as the government would prefer to see it, is not limited to the case where the prevailing party gets the fees, but the government gets it regardless. And there's no other statute other than the trademark statute which provides for anything going to the government regardless of how the outcome of the case goes. So that's a little bit of a summary, a little bit more than a minute. I'll pass it on.
And my name is Pamela Chestek, and I am here to represent the Trademark Bar. So this arose for the Trademark Bar before it arose for the patent.
I have no idea. On the law for patent law. We're not a trade school. Okay, so I learned to wave my arms. Wave my arms. Oh, you are so lucky I was not on the air. That was good. My view, that will make the webinar much better for everybody involved. So my view is the most important argument of all was missed today. I couldn't believe Morgan Chu, who I think is one of the most able lawyers, IP lawyers in the world, missed this argument. It was raised in the government's brief, but then they realized it was a killer for them. So they made sure they didn't ever mention it again. And the argument is, the best argument that was given by the government, I like the government. I paid my taxes today. I love the government. And so basically, the best argument that was given was, well, the AIA came along and now we have to balance our fees. And so, well, because of that, I know we overlooked this for 170 years, but like Saul on the road to Damascus, we have seen the light now. And now we know. And that's kind of a Judeo-Christian ethic. And if I could make it Muslim, I'd do that also. But I have limited abilities. And so basically, where this came up is it came up in the Helson case. And evidently, see, I would thought the Supreme Court would decide this case 9-0 in favor, 9-0 against the government. I'm so sorry, Charles, because you gave such a sincere statement. I think it would go down 9-0 if it had been adequately argued. But what Morgan should have said today, and I read, thank you for sending me the transcript. I was on my way here, and so as soon as I got here, I hid in the back and read the whole thing. What Morgan should have said is, well, wait a minute. If AIA was intended to change 170 years of practice, they could have made it clear. That's why Helson lost in Helson versus Teva. Because the on-sale bar, the Supreme Court said, well, God, if you'd intended to make the law clear, then on-sale now has to publicly disclose the details of the invention, not just the existence of the sale. Well, they would have made that clear. So as far as I'm concerned now, the Congress, and if this case goes down, and as far as I'm concerned, in that case, then the Congress and all those patent law experts who opined on the AIA. I'm a practicing lawyer. I never opine on any litigation or any legislation until it passes. They will be 0 for 2. They missed it first on the on sale. And they sure as heck could have changed the language of 145 to make it darn clear that they were talking about attorney expenses also. They didn't do that. So that is my view from Mars. And aren't you glad I came?
Follow that. Go ahead. Yeah, I was the general counsel of the PTO from 2001 to 2010. And I've deliberately not contacted my former colleagues about this case, in part because I think they didn't argue the case as well as they might have. During my tenure, we did begin charging costs of expert witnesses. But I don't think it's any mystery as to why the office, and I haven't talked about anybody about this, would start charging their legal costs now. They lost the Hyatt case. Before Hyatt, the PTO's position had historically been, from the time before I arrived, and had been from the 19th century, so far as I can tell, that in one of these district court cases, the PTO's findings are reviewable for substantial evidence, and the only new information that can be brought forward is information that could not have been brought before the PTO. And the Supreme Court held that was not the case. So the costs of these proceedings go up remarkably for the PTO to the point where they become the equivalent of a full-time equivalent personnel salary, which was not the case, so far as I know, before. So it becomes an expenditure of the office in ways that it was not historically. They didn't make that argument, or why they didn't make that argument, I don't know. I'll have other arguments they didn't make later on, but that's my first one.
Hi, my name is John Gladstone Mills, and I'm here on behalf of the New York Bar. In about 2 seconds, I'm going to defer to my colleague from the New York Bar, Yun Wong. My pronunciation is not the greatest, but I wanted to make one point out of the box that had to do with our brief, and that is that, and this is just very large sort of overview, but in this, and it was brought up repeatedly in the oral arguments about something called the American rule, which is, was pointed out earlier, each side pays its own attorneys. And then, of course, what wasn't mentioned, there's the British rule, something I'm kind of partial to, where the loser pays the winner's attorneys. And I would describe this is the extreme rule, where the winner pays no matter what, or the appellant pays no matter what. And we wrote, and my part of this brief was largely directed to the chilling effect that this might have on an applicant to bring a matter in the district court, the alternative route that was mentioned.
Isn't that the intent?
If you would tell your client, if you win, you will pay all of their fees, it's going to give them great pause, even if they are right and the law is on their side, and even if the government is wrong and the law is against them. So this is a very, very profound matter, and that's what we are now. I'm going to defer to Yin, who's going to talk about the rest of our brief.
I know.
So much for him.
Well, I was planning to pretend to be John, but then they made me a name tag, so now I get to be myself. Hi, my name is Ian Huang. I'm in private practice in New York as well, and I'm on the New York City Bar Association alongside John on the Patents Committee. So we work together on the amicus brief that we filed in favor of Nantkwest's position. John has given you an idea of one of the arguments we raised concerning potential chilling effects. Two other points we raised in that brief were first, we took issue with the USPTO's characterization of the amount it requested as, quote, personnel expenses, end of quote. Now, I think certainly, I understand why the USPTO took that position given the constraints of the statutory language. But at the same time, our brief set forth the position that, look, if it looks like a duck and quacks like a duck, you have to classify it as a duck. And here, that's basically what the USPTO's position amounted to. They calculated the amount sought in attorney compensation in terms of number of hours expended times an hourly rate. That's basically the lodestar method. If you do that, I mean, it basically is a calculation of attorney's fees, regardless of whether you say it's attorney's fees or you call it personnel expenses or something else. The second point we raised, which I was a little bit surprised was not discussed, was that we identified two cases where the Supreme Court specifically held that attorney's fees and other fees like expert fees were non-interchangeable. Granted, those cases were a little bit different from the issue being raised here, which is that in those cases, it was a successful litigant seeking to recover expert fees under an attorney fee provision. And in both those cases, the Supreme Court said you can't do that. Expert fees simply are not in the same bin of recoverable amounts as attorney's fees. And in one of those cases, Congress actually went back and amended the statute to specifically say, okay, you can get expert fees in addition to attorney's fees.
Great. So that's the positions of everyone on the panel. I want to turn now to what happened today, what happened in oral argument. So the first question out of the box was from Justice Ginsburg, and this was a repeated question all day long about why this statute is different. Everyone agrees that it's different. It's the only, along with the trademark statute, that's also at issue, perhaps in this case, the only statute that makes attorney fees dependent on just the word expenses. And so there was a lot of debate about what that uniqueness or the base of the statute being unique, what difference that made in the overall case. And so anyone can chime in, but what are your views on the statutory language here? We have a unique statute. We don't have a general statute we can follow. Is this a unique statute that makes it different from other things that's supposed to be different, or is this something less than that? Charles?
I'll start off with just a couple thoughts. I think what we observed from the arguments, or at least what I observed from the argument, was I feel like the court was somewhat unsettled by the statute. For some of the reasons that John was mentioning, this is sort of an extreme statute that says that the winner in some cases has to pay the loser's fees. It's very strange, and I think the justices were kind of struggling to find, what is a good focal point for understanding how to interpret the statute. And what that meant was that a lot of their ordinary sort of statutory construction tools went out the window. Ordinarily, we would spend a lot of time looking at other statutes to try to figure out what the statute meant. But there aren't any, so we can't look at other statutes. A lot of times we look at related sections in the Patent Act to try to figure out what was going on. We didn't see any of that. Instead, what we end up having discussions about are, what was the PTO's practice for the last 150 years, and is that even relevant to construing the statute? Things like that. What are dictionary definitions of the word expenses? Well, it doesn't seem like anybody has any good dictionary definitions of expenses. So what are we supposed to do now when we don't have any definitions that we can rely on? I think that there are lots and lots of examples from this case which just exemplify the strangeness of the statute, and as a result, the court really kind of grasping at straws to figure out just what's a good anchor to start the statutory construction question on. My guess is that that's going to make the case fairly difficult, and it's going to make it somewhat unpredictable as a result.
Well, I'll jump in here and say that I don't think it's as hard or unpredictable as Charles has suggested. The part that's unusual, approaching unique about this statute, along with the trademark statute, is that the applicant pays the expenses regardless. It's not dependent on some kind of success. That's the part that's unusual. What's not unusual is the term expenses. The term expenses appears in hundreds of statutes that purport to shift the payment of costs to one side or the other in litigation. And the problem with the government's interpretation is that if expenses is given its ordinary conversational, divorced from context meaning, as including the costs of lawyers, then there are going to be arguments that hundreds of existing statutes which shift expenses are now allowed to shift attorney's fees. So there is a way to make the ruling here narrow and only applicable to these two statutes. But the way to do that is to say that the American rule, which is a background rule of construction, applies. The American rule was understood in 1839, and that absent any indication of some clear statement, a term that was used repeatedly during the argument by a number of justices, absent a clear statement in the statute that there is going to be a shifting of attorney's fees at the end of the case, then there is not going to be a shifting of attorney's fees. And the term expenses of the proceeding in particular, does have a particular meaning, and it's certainly consistent, as Nantkwest's lawyer pointed out at the argument, and as both we and Nantkwest pointed out in our briefs. In 1839, it had a Latin translation of expensae litis, which meaning expenses of the litigation, roughly equivalent to costs. Now today, we have a cost statute that lays out particular types of costs that may be recovered in litigation. In 1839, you didn't have that. So the notion of cost of litigation, expenses of the proceeding, were largely synonymous. And it was basically the costs of being in court, but not the costs of lawyers. And so I don't think the justices had too much difficulty figuring out the entry point, because the government seemed to give up on their initial argument that the American rule didn't even apply in this case because it wasn't a fee-shifting statute. That was what the Fourth Circuit had said in the Shamus case, and that's what the majority of the three-judge panel that initially heard this case in the Federal Circuit said. But the American rule is a background presumption that applies to all statutes. If you were arguing that a statute that says that the plaintiff shall recover damages, or the winner shall recover damages, includes attorney's fees, you'd have to prove that that overcame the American rule, and that's just not the case. I'm going to add one thing that's sort of off the beaten path here. The arguments this morning were the first test at the Supreme Court of a new practice, which was giving the lawyers 2 minutes to make their case before the justices started interrupting them. And I must tell you that it made the arguments this morning, I sat through both of the morning arguments, a lot more civil and to the both learned in this case and rather unwashed as I was with regard to the first case having to do with the question of whether the due process clause requires a state to allow an insanity defense. It allowed a lot greater understandability from the audience as well. But I do, if you want, I'll leap to the conclusion, and I'll say that my prediction is this case is going to come out 9-0 against the government.
I did also find it interesting that the government kind of gave up on the abandonment of the American rule, which was the whole basis for the Shamus decision, which was to say, no, this is just statutory interpretation. The American rule doesn't apply because we're already sort of in different territory where the winner is going to pay. Even if you win, you're going to pay something. Interestingly, after the Nantkwest decision in the Federal Circuit, so Shamus was in the Fourth Circuit, and I'll explain that in just a second. Booking.com was also in the Fourth Circuit. So when Booking.com, so we have Shamus in the Fourth Circuit, we have Nantkwest in the Federal Circuit, then we go back to the Fourth Circuit for Booking.com. If you read the Booking.com decision, the court is is kind of, I think, persuaded by Nantkwest, but are bound by the prior holding in Shamus. But if you read the decision, they kind of are trying to walk it back and acknowledge Nantkwest. So I did find that interesting also that the government seemed to lay back on that. Just to point out a couple distinctions in how this plays out in trademark law, and I'm a little sorry it was the patent case that got there first, because I think the trademark case is a little more interesting. So one, just to address they could always just file a new application, a continuing application. That doesn't happen in trademark law. So we can't do that in trademark law. So that's not an avenue. The other thing that I find, so in Booking.com and Shamus, it was someone who was appealing a decision of the TTAB that their trademark was not generic and merely descriptive. Lost at the TTAB, went to just the Eastern District of Virginia, lost there, went to the Fourth Circuit, lost there, lost every level. Booking.com, so what happens with trademark cases, the Federal Circuit, in the patent cases, all roads lead to the Federal Circuit. So you can take this detour to a district court, but you're still going to end up at the Federal Circuit. You're still going to end up with the same decisional law. That is not true in the trademark cases. So if you appeal your trademark TTAB holding, you go to the Eastern District of Virginia, but then you go to the Fourth Circuit, and the case is decided under Fourth Circuit law. This was incredibly beneficial to Booking.com. Booking.com had also lost a challenge at the TTAB that their trademark was generic and descriptive. They appealed to the Eastern District of Virginia, and they won in the Eastern District of Virginia, and then also won in the First Circuit. So the substantive argument, they won. So it was a very, very wise choice of them to choose this different litigation path. So it isn't just, so in the trademark side, it's not it is indeed often, oh, I need some more evidence, I need experts, I didn't put on my best case at the TTAB, I'm gonna put some more resources into it at a district court. That certainly is one reason, but there's a second reason, which is it's a district, it's different decisional law in the Fourth Circuit. So that's a very, so whether or not it's fair for someone to have that second bite of the apple, whether or not they should be relieved of their attorney's fees because they made a strategic choice for a different set of decisional law. I leave that up to you, but nevertheless, it is a sort of a different facet that we can, or a different avenue that we can follow in trademark law cases.
My view is the government should have had you argue the case, Charles. Well, I thought it was over. I think it's going 9-0. I'm with Greg. It's going 9-0 against the government. I mean, RBG, in her inimitable way, right out of the box, she says, Mr. Stewart, is there any other federal statute that provides for attorney fees on the basis of the word expenses alone? ... Same thing. Stewart says, we're not aware of any. Okay, that's over.
So can I go back to the original question?
Sure. If you wish.
I think the original question was, why do we have this unusual statute? And we've now jumped right to the merits and counting justice votes. Again, I'm surprised that nobody talks about the Hyatt case. In the Hyatt case, the Supreme Court poo-pooed the PTO's worry that applicants wouldn't put their best case forward to the PTO, in part because this provision for paying the PTO's expenses exists, and it would, and so people would have an incentive, notwithstanding they could get a second bite of the apple, to put their best case forward at the PTO and try to win. The same concern that you won't make your best case also applies on the trademark side. In reaction to the B&B hardware case, where TTAB decisions were held to be, in some cases, have preclusive effect in court, the trademark bar got up in arms that they don't really try all that hard before the PTO, and it's unjust to not give them a second bite of the apple where they really will put on their case. I think one good reason for this provision is to make sure that people actually put on their case before the PTO and not create prolonged market uncertainty about whether they may have exclusive rights over against other parties.
If I could just disagree with that for a moment. So B&B was a cancellation case. So saying that, and the TTAB can only decide one thing, the validity of whether or not the mark should be registered. So to say that I should put on my whole case on my full likelihood of confusion, my full marketplace confusion in front of the TTAB when really they have a limited remit.
The point was that regardless, you wouldn't put on your full case with respect to the matters that were before the PTO, not with respect to likelihood of confusion on issues not at the PTO.
There's a huge amount of overlap though too.
I hear you, but I'm just telling you what the PTO heard from the trademark bar.
Right.
And what it heard from the trademark bar is we don't think we have to try all that hard before the PTO. That's what it heard.
Great. So I'll take questions, but I'm going to, if anyone has any questions, we'll take them. But while we wait for questions, I think Justice Roberts, I think it was him, he had a question. Basically, what if the PTO charged a filing fee? Would that be an expense under the statute? And there wasn't, I don't think I got a great answer on that question. But I'd like to hear from the panel a little bit more about how you'd answer that question. Do you think that's an expense that's covered under the statute?
I'll say something first again, I guess. So, like I said, I think that there was, I still maintain my position that I think that the court was really grasping at straws for what was a good anchor point for this case. I think that the thousands of examples of the word expenses, Morgan Chu brought that up, and Justice Roberts didn't think that that was very helpful because he thought that all the other provisions were different. So, in a situation where the justices are saying, we don't know what to analogize this to, the parties, of course, want to provide something. And in the case of Nantkwest, they obviously argued that we should analogize to the American rule, that these should look like attorney fees and litigation. On the PTO, their position was, we should analogize this to continuing prosecution. We should treat the Section 145 action in district court as just another part of the application process where you normally have to pay fees for each part of the activity that you undertake. So you should be paying fees in the same way that you pay fees to go to appeal to the board, in the same way that you have to pay fees to file a continuation application. And I think that that's where Justice Roberts' question comes from. He's asking basically whether or not the government's analogy has merit. Should we just treat the Section 145 action as an odd type of patent prosecution? Sure, it's before a court. Sure, it's adversarial, but why can't we just treat it that way? Morgan Chu's answer, and I thought it was a very good answer, was we can't because of the fact that it's a court. Because of the fact that it's adversarial litigation, we have to treat it in the same way that we've treated adversarial litigation historically for centuries at this point. And, I wasn't in the courtroom, I was in the lawyer's lounge, unfortunately, so I didn't get to see the facial reactions. I'm sure that some of you might have some impressions for how Justice Roberts responded to this. But I think that's going to be the parameters of the debate for the court, whether or not they're more willing to accept the government's analogy. Does this look just like a piece of prosecution, or are they going to accept Mr. Chu's position that this looks like litigation and, all of its trappings? That again is why I'm not going to be making any predictions about this case, because I think that's going to be a sticking point, and I just really don't know how to evaluate what the court thinks on that.
So the Chief Justice asked why the fee shifting statute wasn't just like a filing fee, and in that regard, he pointed out quite correctly that many administrative agencies have a pretty expensive ticket to get into administrative review. He used the example of proceedings before the ICC, the Interstate Commerce Commission, where the filing fee for a particular proceeding could be in excess of $100,000. Well, it's certainly true as well with regard to certain proceedings at the Patent Office with regard to their filing fees. But at the same time, one of the arguments that we also put forth on behalf of IPO was that imposing uncertain, potentially very onerous fees at the back end of litigation, it's not a known fee at the outset, because you don't know how much time and effort and number of lawyers that the Patent Office is going to throw at the case. There's certainly, because this is a novel interpretation of the statute that the PTO has come up with, there's no case law with regard to whether it's a reasonable fee, that their submissions of fees are subject to a reasonableness analysis. They could very well go outside and hire very expensive outside counsel under their contracting authority to prosecute or defend these cases in district court, and then claim the fees back at the end, because they know that regardless of outcome, it's going to get paid for.
No, they couldn't.
Well, okay, Jim will tell me that there's no statutory authority for that, but
they're represented in court by the Department of Justice.
Well, that is true.
By
But
law.
the Department of Justice also hired David Boies to help them prosecute Microsoft. So the Department of Justice has the ability to hire outside counsel as well.
They ain't.
Anyway, the point is that there are small entities that seek patents. Not every patent seeker is IBM or a big pharmaceutical company. There are small entities, and small entities deserve the ability to get into court as well. And this not only chills their ability to go into court to challenge in the administrative process an administrative agency's decision, but it also may just make it impossible for them. The fees sought in this case were in the not quite $100,000, but close to $100,000.
It was 112.
Excuse me?
112.
112. Okay, so I guess it was above $100,000, but that's probably pretty typical of what sorts of claims will be made for attorney's fees in the future. But again, this case will open up a giant can of worms. And I guess I'd like to make one other point here, and that is that I'm not a patent lawyer. I'm a lawyer who does patent cases. And I draw that distinction because I didn't come up through taking IP courses in school and interning at the patent office and
Not
clerking.
that there's anything wrong
Not
with
that there's anything wrong with that path, but and I'm out there hiring those people, absolutely. But I'm then training them that when you're arguing at the Federal Circuit, at the Supreme Court, you have to remember that patent law has a lot more law to it than it does patent. And so this case is, in a way, it's not a patent case. I argued the SAS Institute case a couple of terms ago. And everybody in the patent bar said, we're not going to win that case. There's no way we're going to win that case. And we didn't argue it as a patent case. We argued it as a Schoolhouse Rock case. It was about the structure of government, the structure of courts and administrative agencies and the legislature, and who gets to make the law and who gets to interpret the law. And 5-4, we won that case. And the reason that we did is we didn't envision it at the Supreme Court as a patent case. We viewed it as a patent law case. We viewed it as a law case where the background was patents. So you still have to remember the basic rules of statutory construction. You have to be able to bring in cases from outside the fairly insular world of patent law and be able to argue things like plain meaning, context, American rule. All of these things transcend patent law. And so to me, this is an easy case if you conceptualize it not as a patent case, but as a law case that involves patents.
I wanted to make one more comment about the about Justice Roberts' hypothetical concerning the enormous filing fee. I understood that question to address the USPTO's concern that maybe specific litigants could be very persistent before the Eastern District of Virginia and rack up a lot of litigation costs for the USPTO. So, I think Justice Roberts was essentially asking, well, what if the USPTO just pre-billed those specific people for whatever enormous sum they thought was sufficient to cover the costs of that litigation? And on the face of it, it seems not implausible, right? I think if the USPTO wants to raise fees, which they do regularly, usually that doesn't provoke too much of an opposition. At the same time, I think, would it actually work in practice? I'm not really sure, because a Section 145 case is filed in federal court. As far as I understand, you pay whatever the federal court says its fees are, and that's it. The fact that the USPTO may want some more money before commencing the case, just, there's no place for the USPTO to try and set up a fee barrier like that, as far as I understand.
The question from the PTO's perspective, the question from the PTO's perspective is going to be who should pay this cost. The users of the system are going to pay the cost of the PTO's personnel. And the question is whether that cost should be spread among all applicants or should it be specific to these particular applicants. And so it's relevant to ask the question, what would lead someone to choose this route as opposed to direct appeal to the Federal Circuit, and in particular in the context where you haven't put forward your full case before the PTO. And on the patent side, at least, there are clear reasons why that would be rational to do. And the key one is that you will get more patent term, because if you on an original application, the patent term adjustment will be limited to the extent to which the PTO lets the case slip, and that's going to be less if you don't provide them all your information. But if you go to district court, you will get day-for-day patent term extension, and that's of value to people who don't think the market for their invention is going to arise quickly, but that it will arise slowly. In some industries, that will be big guys. It'll tend to be big guys in the pharmaceutical space. And in some industries, that's going to be small guys, particularly in the high-tech area. And whether or not the full range of applicants should pay for that choice, I think is a fair equity question, which doesn't seem to have been asked.
So really, the conclusion is that Jim should have argued the case.
That's why I didn't talk to my colleagues.
Jonathan.
Yeah, just to the point on the fees. So they have fee setting authority over every stage, including at the appellate stage. You have to enter into the file record a notice of appeal. And $112,000 is not that different from what you file for an IPR or a PGR in filing fees. So it's not crazy to think that they could very easily next year come up with come up with like a $25,000, $50,000 appeal barrier for each stage, including the Federal Circuit stage. And to your point about the chilling effect, I thought Malcolm admitted that, and the office is kind of encouraging that. The reason why they want the statute to be interpreted the way they think it's correct is because it's a choice of the applicant to, after having already appealed and already used a ton of resources at the office, all the way up through the office itself, and probably already cost the average applicant a bunch of money, then on appeal, rather than going to the Federal Circuit, which they still have the ability to do, adding and inserting an entire trial into the proceeding and taking the solicitors away and adding that cost. So there's nothing stopping them under their fee authority from adding a $200,000 fee or a $400,000 fee, as long as it's a reasonable use of their fee-setting authority, and it's tied in some way to the recoupment of costs. They did a study that showed it's average $100,000 for one of these trials, and they tacked on a $100,000 fee to any one of these trials just to file the notice of appeal. I would think that that would probably withstand review on appeal.
Don't ask Tupin to argue for it.
I was going to say, I'd simply point out in response to that we're talking about access to a federal court here. We're not talking
No, we're not. No, we're not, because they have the option to go to federal court, to the federal circuit, or add an extra step and take their administrative proceeding, which they might not even have standing to bring in district court, to a district court, which is Congress's intent, give them an extra chance. So rather than there being 15 decision makers that might see it all the way up to the third stage, 17 decision makers that might see it all the way up to the third stage.
So again, I disagree with your assumption. The Article 3 federal courts are not an extension of the administrative agencies of Article 1.
So what's the case?
No, there are two routes into federal court. One of them gives you the opportunity to put in the sort of evidence that you cannot put in or did not put in, depending on what the record shows in that case. But either way, you're able to put in evidence and have decision by a neutral, non-captured decision maker in an Article 3 court. And it is not for the patent. No, wait, let me finish my thought, please, before you take me off. It is not for the agency to decide to erect what for many people will be an insuperable barrier at the entry point for Article 3 district court. It's not a continuation. It is a challenge to what the administrative agency did. Now, the last point I'll make on this is the answer is not, and this is my SAS bias showing, my SAS Institute bias showing about administrative agencies. The answer is not for the patent office to do this. The answer is go next door, go across the street from the Supreme Court and go into Congress and say, okay, for these actions under Title 35, instead of the usual district court filing fee of $505 or whatever it is to file a complaint, the filing fee will be $100,000. See if you can get that through Congress, but don't do it as an administrative agency. That's my answer.
I'd like to disagree with one thing you said.
Hold on.
He wants his chance at me first.
Fair enough.
Hold on. So there is no appellate standing for an applicant, or there's no standing period for an applicant, because there's no non-administrative case in controversy between the person who's seeking a patent from the office and the office who's denying it, right? They couldn't bring an Article 3 case in controversy outside of the action of the statute, correct?
Right.
Right. So what
the APA
access
still
is being
requires
deprived
Article
other
3.
than that which Congress has already given?
So, I'm sorry, I didn't hear the first part of that last
Congress
clause.
has given them the ability to apply for a patent. So they can apply for a patent in front of the administrative agency. They've also given them the ability to appeal it internally to a board of appeals. And then from there, they've given them the option of either appealing it to an Article 3 decision maker to then review that decision again, or to the Federal Circuit to review that decision. And then again to the Federal Circuit over here if they want to as well. So how would adding a fee to that deprive them of any sort of Article 3 standing or any sort of Article 3?
I didn't say that. What I said was that I'm not going to let the Article 1 administrative agency impose a fee at the threshold of Article 3 review
They
of the
already do.
administrative
They
agency.
have to file a fee to file the notice of appeal.
Yes, it's $505.
No,
And it's
no. I'm not saying in the court. They have to file at the agency.
Yes,
So they have to file at the agency and the court.
and that
You just said you wouldn't let them do that, but they already do.
well, but it's not $100,000. It's $500 or something like that.
So it's
And
the
that's-
amount.
and it's Congress
so
that
it's
sets
the
that.
amount that is a problem here.
It is who sets it, not just the amount.
They
If Congress
set it
wants
right
to set
now.
a $100,000 filing fee, let them do it.
Congress doesn't set it. The agency does right now.
The agency sets the filing fee for, then let them set a $100,000 filing fee at the outset, and then let's have that challenge. But let's not do it through this statute.
Okay.
I'd like to address one very small usage that you had, which is that these district court cases are challenges to what the agency did. I think clearly after Hyatt, they are not challenges to what the agency did. They are new cases. And when the agency hears through the district court process new information that had not been heard before the agency, and it is persuasive, the agency routinely asks for a remand, and the case comes back as an application before the PTO. I mean, I really think that there's some aspects of this that aren't clear.
All right, we have time. We have time for one more question. Anyone want to ask it?
I want to recognize Larry Nodine, who's in the audience, who is from Ballard Spar and who filed a brief on behalf of the International Trademark Association. And I just wanted to give you a chance to add any reflections or insights.
Enjoyed the discussion. I thought you've covered it very well. Thank you very much.
All right, then I do have a question.
Perfect comment.
So my question is, if this is going to be a terrible result, if those of you who predicted a 9-0 ruling for the court in favor of Nantkwest, if the court goes the other way and it is in fact a terrible result for trademark owners and patent owners, wouldn't it be an easy fix for Congress? And wouldn't there be a big, basically all of the bar associations have lined up on the side of Nantkwest. Couldn't those same associations bring their forces together, go to Congress, and have a bill to fix this? And isn't that the way we should fix bad statutes?
I asked the question, in this climate, is there any easy fix in Congress?
So number one, the number of people who will point out that I am the only amicus party on the side of the government is remarkable. I have never seen this many people say that. But to your point, I think they're already predicting that. I don't think that CRS did an update or LAI did their update just for the fun of it. I think they did that because they're expecting this to turn into a congressional fight. And the reason that I think this is going to turn into a congressional fight is a point that Jim brought up, that the people who are really benefiting from Section 145 actions, and this is actually like a small study that I do in my brief, are not small inventors, despite the fact that we had as many briefs as we did saying that this was all about protecting small inventors. I actually looked at all the Section 145 actions that have been filed since I think 2010, and many of them are frivolous. I think the district courts just recognized that they were frivolous. But of the ones that actually had colorable merits, there were 6 of which were pharmaceutical companies, one of which was $1 billion manufacturing company, and one of which was intellectual ventures. So what I think number one that shows is that a lot of the concerns that were raised by folks like the Association for Amicus Council and such, who are worried about access to justice, that's not really borne out in the facts. But number two, what it means is that if there is a legislative fight, there is a lot of money behind that. And I think that this is really going to turn out that way if that's how the court ends up going.
I'm skeptical of fixing anything patent related in Congress. I'm actually skeptical, like Tom, of fixing anything in Congress these days, but the AIA took so long and ended up in the way that it did. Section 101 still seems to be just sort of barely crawling along with regard to the changes that everyone agrees some change has to be made, or at least it seems like everyone agrees some change has to be made, but no one knows what to do, and it's certainly not anybody's priority right now. So the answer is yes, it's true that you can always fix a bad result by going to Congress, but I think the courts still are obligated to try to get the right result first before everybody ought to run off to Congress. So either way, I suspect there will be efforts, whether it be from the government or if my prediction is completely wrong, from industry to go fix this. But I didn't hear in the justices' questions any appetite for making a special rule outside the presumption of the American rule.
Great. So it's just about 6 o'clock. The goodie bags are here. So please join me in thanking our panelists. We have a goodie bag filled with WCL treats. I'm not sure what they are, but they'll be good over here. And please, probably an umbrella. Please join us outside for a reception. And thanks again to their panelists.
Thank you.
Great, thank you.
That's good. Feisty.
I've never seen people so excited over one.
I just wish I'd been able to get.
Yeah.
Yeah.
Nice.
Congratulations.
I'm on the
Pop up
9-0.
there.
Yeah. Well, I gotta say,
how are
even
you, man?
before reading the transcript, I was on the night.
I'm
Never knew
exhausted.
there were
I
so
think that
many
the court,
hours in a
if you
night
look at
that you could
all
be
of-
awake
I
in,
think
huh?
You have no
A
idea.
lot of it, copyright
There
trademarks.
was a couple nights where he was like
Court
every
doesn't
2
like
hours.
special
Yeah,
traits.
So I'm
Copyright
exhausted.
cases,
That's a big
they-
deal.
you know,
Probably a
this
little
is such an outlier.
frothy.
The
Chinese
really
water
was
torch.
almost trying
It's
to
like,
avoid
right? Fall asleep.
being comic footage. It really was very much.
Yeah.
I thought that Stewart did a great job. There. Talking about having a tough case to argue.
Yeah, I thought, I mean, from the, what I can see.
This morning.
No, he did it.
Tell him that I had my caffeine this afternoon.
Yeah.
So.
I had to give you a hard time, sorry.
That's all right. Good to see
Good to see you,
you.
man. How are you?
Good.
Congratulations. I haven't seen you since. I don't think I've seen you since your argument. You did a great job. Since SASS. Yeah, you did a great job. I thought, like you, that it was going to go 9-0 based on the brief. And I think that the government did probably as best as they possibly could have done today. And I thought Morgan was started slow.
What happened?
But